across incorporation jurisdictions. And this is part of the Berkeley Forum on Corporate Governance pre-webinar series. So we're very excited to have a wonderful panel of speakers today. Before I pass it on to our moderator, I did want to turn your attention to a couple of logistical notes. So, for many of you, this is something you could probably repeat yourself, but I will speak at you, those of you who are joining us new. You are going to see a chat function, and in that, you will see the link to sign up for CLE. Please make sure to fill that out during the webinar, as it becomes a little bit more difficult for us to verify when you try to sign up for it after the webinar. So just keep a lookout for that link in the chat. Then, of course, there are two things I want to make note of for anyone who is able to join us. We have the Berkeley Forum on Corporate Governance taking place next week on October 28th and 29th. It's both in person and virtual. We're dropping the link in the chat now. Join us. It's going to be a wonderful 2-day event with lots of trendy topics, a lot of what we've already teased in this webinar series, and doing a ton of deep dives on the day of. So would love to see you there. I also wanted to share a new webinar series we've started, and it's a bit of an experiment. So we hope you'll join us. It's called Beyond the Handshake, and this time our featured guest is Jamie Lai, who is a partner at Cooley. And the goal of this conversation is actually to highlight the human side of the corporate world and who these people are, how they build their relationships, and how you build a career that is meaningful while you're also working in corporate law. So join us today at 12 p.m. Pacific if you're interested. And then finally, if you have any questions or concerns, send us an email at bclb@law.berkeley.edu or drop a note for us in the Q&A, which will be available for you to ask any questions to our speakers as they're chatting. So with that, I will stop sharing and pass it on to you, Andrew. Thank you so much for joining us.
Thank you, Anjali. For those of you who don't know me, I'm Andrew Baker. I'm a assistant professor of law here at Berkeley who teaches kind of our core business courses. So I'm really excited to get to moderate this panel with a great set of guests and what I think is a very timely and interesting topic for everyone. So in this webinar, we are going to discuss the differences between Delaware, Texas, and Nevada. We can touch on other jurisdictions if anyone wants to, but I don't know if anybody here necessarily has a bunch of expertise outside of these three core areas. And in particular, we're going to discuss what is the difference in the litigation environment, questions about judicial expertise, case predictability, and procedural differences. Okay, so with us today, to start, we have the Honorable Vice Chancellor Sam Glasscock, who's going to represent the Delaware perspective. VC Glasscock, you correct me if I'm wrong, but you were Vice Chancellor from 2011 to 2025. Is that correct?
Correct.
Correct.
Yeah, I'm ex-honorable now, formerly honorable.
I'm not changing that one for at least for this hour. You'll be staying honorable with me. He will be representing the Delaware perspective. To represent the Texas perspective, we have Marc Katz, who is the managing partner of the Dallas office of DLA Piper. And then finally, to represent the position of Nevada, we have Benjamin Edwards, who is a professor at the William S. Boyd School of Law at UNLV, who has been writing and commenting a lot on these current topics. All right, so first off, I wanted to say I assume many or most people on the chat probably have followed somewhat what's been going on vis-a-vis Delaware. I don't think that we need to spend a ton of time in this panel talking about those changes, given just the sheer amount of panels that I've been to myself and seen about these questions. But I'll just note that there have been some changes, potentially minor, potentially larger, to Delaware kind of law, statutory law, and decisions, particularly around conflicted directive transactions and controlled companies. At the same time, there have been other changes going on contemporaneously in Nevada and Texas. And that's where I think we should start. So Ben, could you explain to us what's been going on with Nevada right now vis-a-vis business law and the kind of market for incorporation that maybe our audience would not be completely aware of?
Happy to. So within the last 2 years, we've probably seen around, I don't have the precise stat in front of me, but around 18 to 20 20 plus public companies migrate to Nevada from, usually from Delaware, largely because that's where most public companies are, or a substantial, bulk of public companies are. Um, if if you're thinking about, well, are the firms significant? It's a mix. There's, a fair number of firms that have shifted, I think, largely for cost reasons, because being a Nevada corporation is relatively cheap. It's about $700 to $1,000, a year. The subset that's more significant is, TripAdvisor, the Trade Desk, Roblox, four different entities related to the Dolan family, Madison Square Garden Entertainment, Madison Square Garden Sports, the Sphere, I think AMC Networks. And so we've seen some substantial movement, toward Nevada. Um, but these have largely all been controlled firms. And when I say we've seen some substantial movement, um, you have to sort of take these numbers against the sort of overall number in Delaware. So relative to the size of the pool of public companies in Delaware, this is very small. And I would also want to note that even with this movement, Delaware's stable of public companies is still growing because it's getting more entrants from IPOs and other things than it has lost with a number of companies shifting.
And so, have you also seen more? I mean, these numbers are all going to be obviously small, but in terms of the IPO market with firms with controlling interests, has there been a move at all to kind of, like you're saying, if you want to see these numbers, if you're in Nevada and you're a legislator and you want to see these numbers increase, presumably you need to both kind of convince some existing companies, but also get more companies to be IPOing in Nevada directly. And has that begun yet, or is that still?
So we've seen a small uptick. I don't have the most precise statistics at my fingertips. It's on my to-do list to go put this together. We've seen a relatively small uptick. There's also been I think at least one company's come to Nevada via split off relatively recently. And so this is something to watch. I mean, one of the metrics I've been using for myself to see, is this really going to be significant? Is if you see, more movement on the IPO front. Historically, I think bankers have been risk adverse, and the advice they've largely given is that you should pick Delaware because the market knows and understands Delaware. And so that's going to be a transition cost. It may develop to where we end up with more market familiarity with a small number of jurisdictions. So it's early yet on the trend. So we'll see whether it's a blip or anything more significant over time.
That's interesting. I mean, when I teach BA and I talk to my students about, and securities, to be honest, to talk about this specific decision, one thing I say is that, for some of these firms, a lot of this comes down to venture capital as well, not just the bankers, right? That the VC historically has wanted Delaware because, at least notionally, they thought that the case law was more predictable when they're going into, right? And there are disputes with early stage VC companies a lot. We obviously, without getting into this too much, but I've seen a much higher political profile from many VC members as well. And I wonder, given the somewhat weird political valence of what's been going on with certain controlled companies and actually talking about the stuff that we all think about a lot in the public press, is that like maybe a strategy for Nevada to try to convince the VC companies like, hey, look, you don't like certain things, and but then there's weird, right? Because they are kind of contrary to sometimes, at least, the founders who maintain control. And so I wonder if that's part of the game here, is the kind of getting the VC companies to also be interested in Nevada.
So I think for us that's going to be significant. One of the challenges is developing public confidence and widespread confidence in Nevada as an alternative jurisdiction.
Yeah.
Uh, one of the things I've pushed when talking to people locally about this is you have to have the trust and the confidence of the broader market. If you start a company in Nevada and it's being run by Nevadans and they want to raise money, usually the advice you get is that you need to create a Delaware corporation because your investors are going to want to know that they can get a dispute resolved in a reasonable amount of time in front of a judge with a reasonable degree of expertise. And that's that is a pressure, I think, that has historically tilted, even Nevada-based companies to pick some other states law to satisfy their investor base. So if we are successful at developing comfort among the DC community with Nevada, I think there's a chance of an uptick. I do know locally from the composition of my daughter's preschool class and the local housing market and other things that are going on is that we have a substantial number of VCs that have moved to Las Vegas physically themselves. And part of the reason for that is just if you have exits in the pipeline that are likely to occur sometime in the next few years, Nevada doesn't have an income tax. And so if you want to move here and live here, maybe it makes more sense to be involved in what's happening here within the legislature and elsewhere.
Yeah.
So I think it's a hope for us as a state that we can diversify our economy away from gaming and mining to where if there's some economic downturn, maybe we'll be more resilient than we've been in the past.
If
Great.
if they get dissatisfied, Ben, you can remind them that Delaware doesn't have a sales tax, and
That's
we
true.
got some nice places to live too.
Yeah, and you've definitely got better beaches.
Yes, that is true. I have heard about the no income tax in Nevada. Seems nice, and Reno is driving distance from the Bay Area, so for what it's worth. Okay, Marc, what's been going on in Texas at the same time? What is the story with Texas?
Yeah, thanks, Andrew. And it's interesting. I'm glad to be part of this, and because coming from Texas, we often forget that there actually are other states in the country, and so it's good to hear what's going on there. Yeah, we've Texas, I think, has always been traditionally tried to be a pro-business state. But of recent, in the last couple years, there's been some real movements to dramatically increase that. And I think the two most specific things last year were the creation of our business courts, which are much like in Delaware and other states. They're specialized trial courts to focus on complex business disputes, internal entity claims, and trying to get judges who are experience in handling those types of cases, so we can provide more efficient, effective, and consistent dispute resolution. So that's these judges. Like I said, the courts were just created last year. The judges are appointed by the governor. They have qualifications, limits that they have to meet. There is some legal contentiousness in that regard because the Texas Constitution requires judges to be elected. So there are issues there that are still going to play out as with the jurisdiction and the handling of the judges, but that's something that's really ramped up the caseload that are and the cases that are being filed in those courts over the last year. And then this year, the business code was overhauled for the express purpose of trying to make Texas more of a corporate hub, limiting shareholder litigation, making the state more management friendly. That legislation specifically codified the business judgment rule here, provided directors and officers protection against lawsuits against them, both substantively and procedurally. We narrowed the books and record requests, allowed public companies to increase the threshold of stockholders needed to bring derivative suits, and also allowed companies to include jury waivers for all suits with internal entity claims, as well as not just providing a form selection clause, but actually designating specific courts to hear disputes. And we've seen a trend of a number of public companies here opting into these new legislative procedures that they allow, and choosing the business courts to be the forum for these types of disputes. So I think these are potentially dramatic changes that we're going to see, how they play out over time. But those are the key things that have been going on in the last couple of years.
Very interesting. Honorable Vice Chancellor, what's your view from Delaware, hearing kind of this versus, your many years practicing in Delaware? Is this surprising to you to see how fast things can change?
Well,
Or what's your view?
like any good Delaware Maoist, I want to see 1,000 flowers bloom.
Yeah.
So it's exciting to see what is going on. I've gotten to interact a little bit with the new Texas Business Court. I have nothing but respect for the judges on that court. The ones I've met have been very fine. The Nevada jurisdiction, I think, is interestingly trying to be more management friendly or board friendly than the Delaware traditional view. We're a court of equity, and I've been around long enough I remember the race to the bottom theory that Delaware was way too management friendly, and we were dragging the entire system down to the detriment of stockholders. Now, recently it's kind of been the opposite. I don't get too exercised about it as I look at the numbers. This so-called DExit is, I don't think, like a dam breaking.
Yeah.
If you think of the Delaware incorporations as an Olympic-sized swimming pool outside a resort in Las Vegas that's full of corporations happily splashing around, that's not what's drained. It's the controllers lounging in the hot tub. They're the ones where there's been some leakage. And it really is about whether we have gotten the balance right between protecting the stockholders by holding controllers to fiduciary duties in certain situations, or whether we've gotten too far in that direction and the cost is outweighing the benefits. And that's basically a market signal in my view.
Yeah.
So I am not, I look at the numbers and I don't think that, as I say, it's not a dam breach.
Yeah.
Yeah, and I would just say from Texas perspective, at least anecdotally, I certainly agree with Vice Chancellor Glasscock. Is we're seeing a lot of companies move their headquarters here to Texas, but many, if not most of those, are still incorporated elsewhere.
Mm-hmm.
Yeah, we used to have a big company headquartered in Delaware called DuPont, but our glory days are behind us, it looks like, in that respect.
Yeah. So there are different views I've heard around the benefits of having significant companies headquartered in the same jurisdiction where they're located. The argument I've heard in favor of Delaware, which I think applies generally with some strength to Nevada too, is if your headquarters are in say some Midwestern state or Texas, and you come to Delaware or Nevada, there's a good chance that the corporation is not going to have very deep political relationships in the state, or the ability to kind of serve you some home cooking in front of the local courts. And so for investors who want disputes resolved without worrying about whether the governor would appoint say a different judge if the case is going badly for the company, those kinds of considerations I think are not really in play if you're in a different jurisdiction than where you're headquartered for your investors. At the same time, Fidelity National Financial recently shifted its domicile to Nevada, and they have enormous operations here, and that's I think that's been the trend we've seen, is a lot of the companies that have moved often have significant ties to the jurisdiction. For example, Tesla, I think, is headquartered in Texas. Dillard's, which shifted to Texas, I think is headquartered in Texas, has substantial Texas operations. And they do have a very nice store not far from me, but I will continue to shop there despite them going to Texas.
I mean,
Well,
is it?
Ben, you just said something that's really interesting to me. In Nevada, can the governor get involved in case assignments?
No,
Okay.
not currently, not in case assignments or in appointments. So the reason I don't mean to, I don't want to go after Texas here because I think that we're all friends. Um, but Texas has a constitutional provision that essentially calls for judges to be elected, and appointed positions cannot be for I think more than 2 years. And so what that means is you're appointed by the governor. You have a 2-year term. Texas has been a red state, for a long time. But if it suddenly switches to a blue state, is the composition of your court going to change, with the next administration? And if you think about most cases are not going to be filed on the first day of the judge's term. So, you sort of expect, on average, you'll have about a year left, when you show up. So that's one of the benefits. I think Delaware has a 12-year term.
12-year term.
Nevada judges now have a 6-year term. And I expect Texas will probably amend its constitution or seek to amend its constitution on that. Just on the judicial front, I think people tend to understand stability, predictability, are good things for getting companies to rely on the jurisdiction. I think there's a
Yeah.
default expectation now in Texas that the judges will be reappointed.
Right. And it is interesting that, I mean, so far the legal challenges to the constitutionality for the business courts and some of these amendments on the corporate code have been unsuccessful. Doesn't mean that won't change. I do know that the business courts are also very focused on establishing their own body of law as far as providing the written opinions on the topics that they think are important and to coalesce with the stated goal of trying to provide consistency and certainty to those type of disputes. But certainly that's going to be an ongoing dynamic.
I mean, something from the outside, if you're thinking about states, which I think is interesting because when we teach, we don't think that much about the state's perspective here. So it's interesting to think about this. I mean, what I tell my students is, look, I'm assuming it's the same in Nevada and Texas. I know in Delaware, right, incorporation fees cap, they quickly hit a cap, right? And so, if you're really thinking about maximizing the revenue from that, if you're a Delaware legislature, right? If you lose Facebook, you know, I mean, it's not great, but it's not as the same as if you lose Facebook at their headquarters state, right? That the revenue hit from that is so much larger. And so it is interesting to think about if we're actually talking about incorporation, it's a volume business, right? More than it is. And so, is there a risk from states of catering too much to controlled companies who have idiosyncratic preferences, perhaps on certain things? And then, you really lose, for whatever reason, something shifts. Investors who have much more power with uncontrolled companies don't want, feel as though the burden has shifted too much. And then you lose a massive amount of on the volume side. And that seems like a difficult tension. Now, I imagine it's the law firms. What I would say, I think that the law firms probably are very important in determining where you should get incorporated, and they get more fees from the large control company. So I don't know how it plays out. And so you have to keep them happy too. It's a very complicated game, I feel like, that the legislators are playing here.
Yeah, I believe in markets, and I think it's a market, and I think if Nevada or Texas gets too stockholder suit unfriendly, that
Yeah.
there'll be a price to pay. But I haven't seen statistics on it.
Yeah.
That's just my gut market based answer to what you said.
And
I hope that's the case. I hope it's a market and it's rational. The controller cases are such a small subsection of this,
mhm,
and the idea, the basic idea of holding a controller liable as a fiduciary when you think about it, is kind of a strange one because a controller is a stockholder. Usually, duties run to the stockholders, not from the stockholders.
Hmm.
And the question becomes, when does that flip? When is the controlling stockholder operating in such a way that has usurped power of the board and is controlling the property of the stockholders such that the minority needs protection? That's a question that I don't think statutes are very well designed to answer. I think common law is probably the best way to develop that case law. Now, there was a feeling in Delaware that we'd gotten it wrong to an extent. The legislature acted. I think that's perfectly appropriate if that was the belief, but it still leaves much room for the common law to address these issues.
Yeah.
I see, two major constraints on what states are going to do here that I think, or like that are just going to limit, what's going to happen. So the market, I think, is the first one, and so here, right now, there isn't any significant or material premium or discount between incorporating in, Nevada, Texas, or Delaware. The market does not currently seem to react to these kinds of decisions. If the market loses confidence or minority stockholders lose confidence in a jurisdiction or their ability to get justice or be reasonably protected, they can sell the stock. And if that creates a discount, if you're a board of directors that holds substantial equity and you could make the stock go up 5 or 10% by leaving town and going to a different jurisdiction, I think they're going to leave. Even controlling stockholders, if they have a $900 million corporation and they could become a billionaire by moving jurisdictions, I think they're going to, because you're sort of cutting your own throat
Yeah.
if you don't give enough confidence. And the other here is that if a jurisdiction is catering exclusively to controlling stockholders, the other major constraint is, well, only controlled companies are going to be able to make the move to that jurisdiction, because if if you can't win the vote or you can't convince stockholders to vote in favor of it, you're just not going to go and you're not going to propose it. So I think those are meaningful constraints on what states are going to do. And if a state overreaches and pays a market penalty, I would expect them to move quickly to address it.
I think that's from my perspective as an academic, that's fair. Although I'll just say, like, we like to say in the law that markets work, and it's unclear to see exactly how a market works here when the decision makers are different from the people. Like, I feel like you get tipping points, which is kind of maybe what we're seeing a little bit now. That I don't think this happens, like you said, the market doesn't, I don't think, price this continuously, and I think it's you get to a point. I think you are seeing now, at least vis-a-vis some of the stuff with the SEC, which I don't think we need to discuss, but is always in the background here for everyone, that the Council of Institutional Investors, the institutional investors, I think, are finally starting to wake up a little bit. And we'll see what effect that has. Marc, I'm curious what you think about with Texas. I mean, like you said, Texas, holds itself out as being very business friendly. It's very clear to me what that means when you're talking about something like taxes, regulations. Like, what do we historically think that means to be business friendly? There's complexities there too, but holding that aside, it's
Sure.
not clear to me what that means versus when we think about all of the stuff we're talking about here. Because, like, you could say manager friendly, but a company is a weird, complicated bundle of managers, investors, and so how do you think about getting that balance right when you're trying to kind of really wholly redesign something? Is it just manager friendly? Is it, I don't
Yeah.
know. How do you balance that?
So, well, the legislature hasn't asked me my opinion yet. So,
Yeah. Yeah. To be clear, when I say you, I'm talking about you as
I know I'm joking. Yeah.
yeah.
Yeah. So look, I think it is a complicated balance, and I think that, and by the way, there are the I don't mean ancillary in a immaterial way, but there are ancillary issues like you mentioned, like taxes and real estate and workers and things like that that need to be balanced, that are a major factor um, for companies when they're making these decisions. And I think Texas has historically been on the forefront of a lot of litigation issues. We've always been a state that's had a broad range of courts and a lot of litigation here and a lot of decisions here. And so I think that, the balance of wanting companies to feel that they can come here and have the upside of certain things and some protection from some of the downside. Not that litigation is a negative. I mean, litigation is the way our society resolves its and it's very positive point. But I suspect that the explicit purpose stated in the new business corporations laws to protect management might be well in part to the perceived or actual litigation risks that are here when you come to Texas. We have and one point that Benjamin made, which is the right point, that there is definitely an element of politics that comes into how judges are selected and what that means. But that's just not on a statewide basis. That's on a county basis. And so Texas is a red state, but we certainly have large jurisdictions that are very blue, and their judiciary reflects that. And so it's a balance of all those things. And I think the legislature was trying to do a mix of creating what they think companies are going to see as the right environment. Obviously, only time will tell on how that goes. We also have some other developments in Texas with the Y'all Street, the Texas Stock Exchange, which is opening here, the New York Stock Exchange moving their Chicago branch down here.
So do you call it Y'all Street? Is that?
Yeah, that's what
I had not heard that yet. I like it.
Yeah, it'll be interesting to see how that impacts the business environment. Obviously, that's not a legislative controlled or push thing, but it's something that I would say leadership in the you're talking about business leaders and political leaders and community leaders are trying to foster Texas as again more of a pro-business state, which requires thinking of very much through a lot of those issues that Andrew, that you mentioned, that making sure you're actually getting what you think you're getting.
Yeah. So one thing that's come up, and I think this would be, a substantive area that would be good for us to dig into is judges, right? So there's, we can talk afterwards about, I think the balance between common law and statutory law and business disputes, I think is interesting. But judges are, when you hear about why people like Delaware, I think, not to, be overly effusive here, Vice Chancellor, but, the argument is, look, Delaware has done a really good job of getting very smart people to fill the bench, who take the job very seriously, who work extremely hard, who write very detailed opinions, and has had a kind of emphasis on kind of some measure of partisan balance that I think has been very helpful to Delaware. And so, could you briefly discuss kind of how do judges or chancellors, sorry, vice chancellors and chancellors, how do they get elected in Delaware? Or how do they get nominated? How do cases get assigned? What's the process that has made, at least for a long time, people to say, look, this is the gold standard for how to resolve business disputes? So what is it about that's the kind of magic dust for Delaware?
Well, Delaware is somewhat different from Texas in that we've got unified court systems, which we can do because the northernmost courthouse in Delaware is 90 miles from the southernmost courthouse in Delaware because the state's not any bigger than that.
Yeah.
So it's easy to have consistency in the courts. So that's the first thing. We don't have county judges. We don't have elected judges. And I gave a presentation at SMU a couple of years ago. And, appointed judges, the fact of appointed judges in Delaware is completely non-controversial and has been so. It was true when the state was a moderate Republican majority state, and it's true now that it's a Democratic majority state. Nobody thinks about it. But there was discussion at SMU about whether the appointed judges for the business court should be longer terms, and whether the whole idea of elected judiciary was good. And a lot of people seem to be horrified. I know that's anecdotal, but
Yeah.
there were people who were just, reacted to that with some amount of disdain. I think we've got a really good system in Delaware. So the key to reducing the politics is the balance that you described. We used to have a constitutional provision that you had to be one of the two major political parties. That it's been suggested by the Supreme Court, although they never got to it, that that's unconstitutional. But what they suggested, or at least one of the concurring justices suggested, was the position that we have now, which is you can't have a majority of judges belonging to a single political party. And that takes the pressure off the governor in appointments. It sounds like it would be more partisan in a way. You have to be one of the two major political parties, but it hasn't worked out that way. It's worked out as intended. The selection system is also, I think, unique and pretty good. There's a board called the Judicial Advisory Board that has to pick a panel of judges. So when there's a vacancy, this board, which is composed of practitioners, lawyers in the state of Delaware, and also non-lawyers, they do the initial interviews. So if you apply, you go in front of this board, and they come up with a list of 3 names. The 3 names are submitted to the governor. He has 2 choices. He can pick one, or he can reject them all and ask for another slate, which rarely happens. So that also takes the pressure off the governor. The governor can say, look, I've got to appoint a Republican, and this extensive review process has given me 3 choices. I'm going to pick one of them. That really takes a lot of the political pressure off.
Yeah.
And the 12-year terms. And that is one great difference I see with the Texas Business Court. It's already been pointed out that if the judges really were going to change in 2 years, and I know there's an understanding they'll be reappointed, but you would have 2 or 3 judges on every large case. So you get stability. I think the Delaware legislature, it's not that they're any better or worse than any other state legislature, but they know which side their bread's buttered on, and it's having a professional, decent judiciary that is not a detriment to incorporation in Delaware. We get so much of our state revenue from franchise taxes and its cheats. So it's extremely important, and they take it very seriously.
Mhm. All right, Ben, how is it going to work in Nevada, at least as you're sitting today?
Okay, so there's a lot to keep track of in terms of what's happening here. So the easiest place to start is just the status quo. Nevada's constitution calls for electing judges. They serve 6-year terms. Clark County is enormous. It's where Las Vegas is, Henderson is, North Las Vegas. The 3 largest cities in the state are all within Clark County. And so we will elect a really substantial number of judges in down ballot elections. They will serve 6-year terms. And it's really kind of a mixed bag in terms of what you get. You'll have a mix of experience. Oftentimes, the people that run tend to have significant criminal law experience. One of the games I like to play when I get fundraising calls from judicial candidates is to ask them what their view is on derivative litigation, and they'll say, "What's that?" And we'll have a good laugh, and then I'll tell them to call me if they end up with some business court stuff. It's also a mixed bag in terms of the diversity of the judicial pool. In low information races, having a name that sounds different in some way, may be a detriment in a kind of a low information race. So the judges
is a name that sounds different a dig at me?
No, no.
Oh,
It's so what I'm thinking of is this is we have observed, and I don't want to go naming names or anything right here, but and more classically Anglo-American names tend to outperform against women tend to perform better than men. It's
Women perform better than men
oh yeah, yeah.
in Nevada.
Well, so what's in a name? Here that may be a factor in who gets elected.
Yeah.
So the judges who are elected right now under the current system, there are two business courts. There's one in Clark County, the other's in Washoe, which is where Reno is. And the chief judge of Clark or Washoe will appoint from among the pool of elected judges a subset of them to handle business court. Now, our business court currently is a business court docket. Um, the wrinkle here is that the judges that are business court judges are also general civil judges and sometimes also criminal law judges. So you'll have a judge that's handling business law matters one day, and then is handling car wrecks the next, and then is sentencing somebody the next day. It's a very busy week, and so that I think has created a bit of a slowdown in terms of your ability to efficiently resolve business disputes because you have to turn and meet your Speedy Trial Act deadlines and these other things because you have multiple dockets that a lot of these judges balance. So what we did in 2025, and I did a lot of work on this and drafted the initial proposal, was we looked at Delaware, and there's a lot to admire about how they select their judges and how they exclusively handle business law matters. And so we proposed a constitutional amendment to authorize an appointed business court. And so the idea is you would have a nominating commission that would give a list of names to the governor. You would aim for partisan balance and these other things. And then hopefully the governor would select from that list, and you'd have a judge that would handle exclusively business law cases. This is lots of states have done similar things over time. It is an enabling amendment, so it doesn't provide any funding. So the legislature will still have to pass a bill. The wrinkle here is that amending the Nevada Constitution is remarkably difficult. You have to pass the legislature twice, and then you have to win a referendum. So we passed the legislature in 25, and the next legislature that could do this is going to be 27. So we have to pass the legislature again in 27, and if that's successful, there'll be a referendum. And so if the public votes in favor of it, then we'll have an appointed business court. One of the I kind of think about this as a reverse field of dreams. That it's hard for us to build it and get companies to come, but if companies are coming, we can get their help to build it because they become stakeholders, in Nevada, and they'll have an interest in transitioning us to a more stable and predictable system.
Ben, do you
So
have
with all that,
a feel for the popularity or lack thereof among voters for this kind of appointed judiciary?
So I think it really depends on how it's pitched to them and how they understand it. So if it's you're not going to have to go sit and do jury trials in this, or your other matters are going to move faster. Or this can increase the revenue for the state, so the schools might get better. It's a mixed bag. Generally people do like to, if asked, do you want to vote for judges? They'll say yes. And then when it's time for the election, you've got 25 different judges to pick through. They say, this is too many. I don't know what to do. And so, it's a mixed bag. The Nevada Supreme Court is trying to improve the status quo right now with a commission to reorganize the existing, business courts to where the Supreme Court would take more control over who's serving on the business court, and the judges, instead of handling multiple dockets, would only handle business court, which should expedite matters and make things move more quickly. There is a wrinkle here that if you are an elected judge that is then selected under this proposal to handle business court, what happens if somebody runs against you? Are they going to be a business court judge or not? Or what if they campaigned against you saying that you are the sort of person who's so snobbish, you're not willing to help people get out of jail by taking criminal cases? it's a challenge. And the other wrinkle, and I'm working on this to try to get statistical data, is informally, that the accident and injury lawyers tend to donate significant sums in judicial elections, and defense lawyers do not. And so, if you are a business court judge, will you be able to raise the money you need to win re-election if you face a challenger? And that's just so you have all these other issues that come with with having an elected judiciary, and so shifting to an appointment system would get rid of a lot of those. But it remains uncertain exactly what's going to happen, but it's in process, and there should be more on the Nevada Supreme Court website very soon.
I've got to think that the average voter, I'm thinking of talking to my wife who never wants to hear me talk about work, and if I had said, do you support nominating judges to a business you know what I mean? I
Yeah.
got to think it's an open slate for the the TikTok messages or whatever it is you need to do to win votes these days, because I got to think the latent strong opinions on this outside of our little circle has got to be very low.
Yeah.
Marc, what about Texas? How so we talked briefly about that right now the rule is you have to be elected, otherwise it's only a 2-year term. So where do you see this going maybe in the next, I don't know, 5, 10 years?
Yeah, so I think certainly in the near future, it's going to remain for the business courts as appointments. There's already been one constitutional challenge um, to the business court system, and the Supreme Court upheld it. And I think the rationale and that was focused on the business courts court of appeals, but the Supreme Court in issuing that opinion. I think the reading of that is that a challenge to the district court business courts, the trial court business courts, would be upheld as well, for the reason, Andrew, you just mentioned, that they're within the 2-year term. So I think that's the way it's going to be for the foreseeable future.
Mhm.
Which is, and look, I have that debate with my colleagues all the time about elected versus appointed judges. I personally, I see the results of the elections and the relatively small number of voters who actually vote for the judges as opposed to Congress people and other candidates. Um, and then coupled with the fact that in Texas, like I said, we have a wide and varied judicial system. So we have, which the jurisdiction of the courts, of the district courts here, change it county to county. We have some counties where the judges hear civil and criminal disputes. Some they hear civil and just civil, and the makeup of the judiciary in those is very different. So of it say, which is why the groundswell of movement to create the business courts was so successful.
Mhm.
And I think that the business court judges are really leaning into that and understand that they're trying to build something that's going to be a boon for businesses that operate here going forward, such that hopefully there'll be less of a political fight about this
Yeah,
voting versus appointment.
gotcha.
I'll tell you what a bizarre little place Delaware is. Nobody bats an eye at appointed judges, but up until fairly recently, the last couple of decades, the courts couldn't appoint their own chief clerks. The chief clerks of each court were elected offices. So it, it's just an odd perspective, I think, where you're electing the clerk of the court, but not the judges of the court.
That is somewhat wild if you think about it. Hey, so we've got about 10 minutes left. We have to end on time. I had a couple more questions, which we could get to, but I think a more fruitful use of our time will be to see if there are any questions that can go in the Q&A. We have one so far from Julia Sienski. She asked, my main question is still on the location argument, i.e., my executives and directors live in Nevada, so we should be incorporated in Nevada. The main argument is that companies headquartered in a state have greater sway with the governor who appoints the business judges. Otherwise, I see no benefit.
Yeah.
Anybody have any thoughts on that?
So I'll jump in. A lot of the companies that have moved, have significant operations in the state. There are, I think, other benefits to being sort of co-located with your headquarters and your corporate jurisdiction. You don't have to travel. You are you'll probably be able to use counsel locally who are more familiar with your matter and your company and work on it regularly. I mean, there's shadow benefits. Oftentimes, this is kind of a joke, but if you're thinking about the quality of accommodations and food and other things, that if you have to go to a jurisdiction for a 2-week trial, where do you want to be? And so those, unless there's something about the law of the state that is a better fit for your company than the location decision or the relative to your location. I think it's something you want to consider, but I don't think it drives this particular issue.
Can I ask one question related to this, which is kind of something I was getting at the last one, which is so Delaware, right? You have a dispute. It gets pushed to Chancery. Is it random in Delaware, Vice Chancellor Glasscock, in terms of how cases get assigned to a specific
You
judge
mean, oh, inside the court,
inside
judge
the court?
to vice chancellor or vice chancellor. It has historically been completely at the discretion of the chancellor. That is changing, and it's changed. It's changed in the last year or so. There's
Hmm.
been some systematized randomization, if that's English. I don't think I just
Yeah,
spoke English, but you get the drift. There has
yeah,
been a move toward distribution system that is not just at the will of the chancellor. The nice thing about the chancellor being able to do it is she knows her judges, and there
yeah,
are people that like certain things that
yeah,
have a background in certain things, but it gets distributed pretty. I mean, it's distributed broadly. There are
yeah,
too many cases really to do anything else
yeah.
because the court is kind of drowning. To answer the question, where would you like to be, involved in litigation near your home or stuck somewhere else? The answer is obviously Rehoboth Beach, Delaware. So, I would suggest Georgetown, Delaware is a place to try these things.
Gotcha. Yeah, yeah, yeah. So what about, but for Mark and Ben, like, can if, as we all know, there's been a large amount of changes to, the way patent litigation was occurring, for example. Is there a risk of that in Texas? So can you do selective filing in ways that could try to get you some forum shopping with specific judges with the way it is now, at least? Or is this something, 'cause I think that's an advantage of Delaware. I mean, obviously, I guess historically the chancellors had
Sure.
some way to, you could imagine a bad story. I don't think that anybody thinks that's happening of kind of getting specific cases in front of specific people, but I think the worry is selective filing in in different cases for business disputes could be a real benefit or a real problem depending on which perspective. And so I'm curious how much you think that is something that Texas and Nevada have to think about.
So on the Texas side, with the business courts, I would say two, one, they're so new. We're still
Yeah.
seeing how all this plays out. Um, because right now we have separate divisions and
Mhm.
one judge, in some divisions just have a single judge. There could, in theory, be a little bit of that by filing in a division where you really feel good about that judge, or at least the judges in that division, because you're gonna
Yeah.
wind up with one of those judges. I think again the court is very mindful of that and very active at trying to provide consistency and across that. Certainly, I think that the business court system would reduce because of that, and because generally you're not well, you're going to have less of that than maybe in Texas you do now, pre-business courts, the system. But look, I think there's also an issue here, maybe addressing the question that you received on the chat that um, I'm a litigator and I see more frequently forum shopping between states, and so there's and as we're increasingly seeing states have very different substantive laws and different and these type fiduciary issues, trade secret issues, those types of things. And you've got states that try to mandate jurisdiction in their state, and you got multiple states doing that, And I think that body of law, we're going to need to see how that plays out, because I think that's going to be very important in determining whether you're going to actually get the protections that you think you're getting by moving to a state.
Gotcha. Yeah, makes sense. What about for you, Ben? Do you think, with the way it works now, right? If you like, is there a way to, are you worried? Do you have to be worried about strategic filing?
So the consideration like I've seen here is if you domicile in a state, you're also admitting that venue is appropriate within that state, I think, for intellectual property cases under the Supreme Court's TC Heartland decision.
Mhm.
Delaware has the Delaware federal courts have a huge volume of intellectual property cases. And I think it's just because you can sue companies that are headquartered there. I don't think there's a perception that the federal courts in Delaware are slanted in one way or another on intellectual property issues. So, if you come to Nevada, you would have, Nevada judges or the federal judges, who are here. Um, with anything, I think if you're thinking more about those IP cases, you would expect if you want a clean slate, you've probably got a better chance of that here. If you want, someone with more experience on those cases and handling those matters, then maybe, you go to an alternative jurisdiction. So it's
To be clear, I was not talking about IP. I'm talking about, I was just using that as an example of where we saw kind of one, specific place getting like 80% of the IP cases. I think we all know what was happening. And I guess for me, as somebody who thinks a lot about business law, I think what's really been great about Delaware is that's not been, and that seems to me as though it would be a repeated and consistent thing in high level business disputes, that if it was, you're trying to get any advantage you can. If you're in a system where, you file in a regional courthouse and you know who you're going to get, even if it's just reducing uncertainty, not even because of, so you know what I mean? Like those type of things, I think would be something I would be thinking about a lot if I was making incorporation decisions. And so I didn't know if, given the structure of Nevada, if that's something that we really have to.
Yeah, right now I'm not aware of any differences in precedent or adjudication style
Yeah.
between Northern and Southern Nevada. Clark County has a much higher volume of cases than Washoe.
Yeah.
It's so if you want to move your case faster, I might tilt toward Washoe right now just because they don't have as much volume.
Yeah.
But I'm not
Yeah.
aware of anything that really moves the needle in terms of local precedent or adjudication styles.
Gotcha. All right, we have 2 minutes. Any last thoughts from everybody about high level discussions about state incorporation races?
I think for me, the way I think about this is that there's probably no one right answer for what is the right balance for corporate law. It's you're going to have some companies that it's better for their shareholders to be more protective of management, and for other companies it's better for their shareholders that you have more of a right to sue and intervene in these kind of things as a shareholder. And so um, I think that's where we're at, and offering different flavors of corporate law, I think is fine.
Anybody else?
I agree with that. I agree with what Vice Chancellor Glasscock said, that at the outset, that that's it's sort of the market system, and we'll see how this all develops organically. And I think it's good that states are thinking about these issues and companies are thinking about these issues, and I think it will end up being better. If nothing else, everyone will be more informed.
I agree. I think the market can only improve things. Um, and I'd just like to say thanks to Berkeley for letting us do this. This has been fun.
Thank
Well, I'm
you,
going to
Julie.
jump on in, Andrew, and thank you so much, Vice Chancellor Glasscock, Benjamin, and Mark. It's just been a fantastic conversation. This is our last one, and we'll see everyone at the forum next week. For those of you who can join us in person, just taking a quick moment to say thank you to these experts who've really helped us dive into this topic, which I know is at the top of everyone's mind, anyone who's practicing in this space. And Andrew, wonderful moderation. Appreciate you jumping in and helping us unpack this issue. Everyone, we will see you soon. If you are able to join us at 12 today, please do 12 Pacific. In the meantime, thanks everyone, and we'll see you hopefully soon.
Thank you.
You.
Thank you all.
Thanks. Thanks, Andrew.